Today we are taking a quick look at the case of Supriyo versus Union of India, popularly known as the same-sex marriage judgment. This case was primarily argued before the Supreme Court of India for the recognition of a right for same-sex marriage under the Special Marriage Act of 1954 as a matter of a fundamental right guaranteed under the Constitution of India. In its judgment, the Supreme Court held that marriage is not a fundamental right in itself. The Special Marriage Act cannot be read to include same-sex couples, and while same-sex couples cannot adopt together, they do have the right to live together in peace with protection from harassment. The court also held that transgender persons who are in a heterosexual relationship can enter into a marriage. While the court held that marriage is not a fundamental right, the Chief Justice of India in his judgment wrote that the sole purpose of marriage is not to facilitate sexual relationships or procreation. Marriage has an emotional component which cannot be relegated to the background. The court also observed that marriage has gained significance because of the benefits that are realized through regulation. Some of the entitlements that the institution of marriage directly affects includes succession rights, maintenance, next of kin privileges in the case of a medical event, financial benefits under the Income Tax Act, and employment benefits. It is in this regard that the Centre during the hearing of the same-sex marriage judgment had given an assurance to set up a committee to look into providing rights and entitlements to the queer community. One must keep in mind that the Supriyo case is currently under review before the Supreme Court. As of April 2024, the Centre has constituted a 6-member panel to look into the issues faced by the LGBTQIA+ community, with a focus on examining anti-discrimination measures to be taken by the centre and state governments as regards to access to services, social welfare, and measures to ensure protection of the community from acts of violence, harassment, and involuntary medical treatments. It bears mentioning that Justice Chandrachud, in his concurring opinion for Navteej Singh Johar, had remarked that decriminalization of Section 377 is only a necessary first step in the path to guaranteeing LGBTQIA individuals their constitutional rights. Thus, while the establishment of the committee is a welcome step, there continues to remain a need for legislation that protects the queer community from discrimination and provides them with equality under the law.